So I was looking at this as Ron was giving the lead in, and it was obvious that there's one of these that isn't like the others. And a little bit of a head scratcher as to why we have this agenda of such exciting technologists, technology companies talking about all of the exciting technological innovations that are ongoing in AI. And you've invited a lawyer who we all know lawyers will be very shortly obsolete and replaced by all of these AI technologies to kind of throw a wet blanket on the proceedings. However, as Ron alluded to, I think as this new Wild West in Silicon Valley around AI and the risk associated with it, along with all of the exciting applications and benefits, there is going to be a need for increased collaboration between risk management teams, general counsels, and others at virtually every organization, simply because AI is so broad and so pervasive and economy changing that virtually all companies will, at some point or another, be spending money on AI applications, on developing AI. And in order to manage the landmines of risks that are associated with this new technology, there's going to need to be a coordination amongst the technologists on the one hand, the data scientists, and management and risk management folks on the other. As we all know, new generative AI tools are being released for use at an unprecedented pace. OpenAI's ChatGPT reached 100 million monthly users faster than any other technology in Silicon Valley's history, including Instagram and TikTok, achieving that milestone within 2 months. And there's a proliferation of other chatbots and other AI technology, including GitHub's Copilot, Stability AI's Stable Diffusion, an open source model, Google's Bard, Llama with Meta, Adobe Firefly, CodeGen, and others. We're also at a stage where AI and machine learning is affecting the global economy. Some, without really being too hyperbolic, are calling AI's economic and social impact the fourth industrial revolution, or perhaps the second information revolution. There's a convergence between artificial intelligence and the various industries of big data, Internet of Things, cloud, essentially information technology, and the overlap between those large swaths of industries in the technology space. There is a whole slew of industries with immediate potential to put AI to practical use, including healthcare, automotive, financial services, transportation and logistics, the TMT, technology, media and telecommunications, retail and consumer, energy and manufacturing. All of this is also creating a significant consumer attention and regulatory attention, as well as a plethora of legal controversy. As Ron had put up on the screen, Silverman and others are, as these new chatbots and AI technologies were first released near the end of last year, there was an immediate explosion of initially copyright technology and other legal challenges to the outputs and the inputs that are used in these types of systems. Some of my colleagues recently attended a conference of state attorney generals and took some notes on some of their observations. And I think it would be useful and interesting to hear how they're kind of thinking about the challenges ahead. AI is currently in the hands of just a few corporations. Large training costs, not a game anyone can play. There's a component of concern among attorneys generals, among the federal agencies, the FTC and the DOJ, around the convergence of AI regulation and antitrust, and the increased focus over the last handful of years on Silicon Valley in terms of antitrust scrutiny, and perhaps having the antitrust mechanism be a tool for governing and kind of pseudo-regulating the AI space. They're concerned about AI being able to exacerbate existing biases, widespread privacy concerns, could make, as I mentioned before, the jobs of many obsolete. Will generative AI replace artists, musicians, and photographers? Creates a potential risk to consumers. They acknowledge that AI is good for consumers in many ways, but not necessarily always anti-competitive, but can enhance anti-competitive conduct. They're thinking about requiring mandatory disclosures. The regulators and third parties need transparency. They also pose the real practical question that regulators have been trying to regulate social media for years. And what is the likelihood of seeing meaningful regulation in AI? They note that California has a bot disclosure law. We're likely to see more state regulation and involvement of state attorneys general, and less likely to see federal regulation. They also note that recently 7 big tech companies went to the White House to discuss AI. They go on to describe that from their perspective as regulators, they need to be sure that they understand AI and not let it intimidate them. That means that they need in-house expertise, data scientists and AI experts to better address how the technology works. They acknowledge that they should not fall into the trap of thinking that everything that falls into AI is the same. They're concerned about the creation of dataopolies. Given that AI learns from data, they need to make sure that big tech doesn't have control of all of the data. They are concerned that entities with the most data will be able to leverage it to exclude competition. As I mentioned before, with the rise of AI, state attorney generals are likely to utilize antitrust as one of their enforcement tools. And there also is a burgeoning nonpartisan spirit of collaboration and cooperation among state AGs and federal agencies, most notably the FTC and the DOJ. Notwithstanding this convergence of interests, this convergence of commercial applications and the deployment of exciting AI applications, the convergence of these events, there is no existing government regulatory framework anywhere in the world. And so how does one manage these risks in anticipation of regulations that are under discussion, but do not yet exist? I'd like to kind of answer or set a framework for some of the thinking around this based on a cross-practice initiative around artificial intelligence that has been in the works at Orricks for approximately the past 5 years. We have an interdisciplinary team of IP, data, tech transactions, fintech, employment, and competition lawyers that are assisting numerous clients, large and small, with risk counseling as they develop, commercialize, purchase, and use AI tools. Our litigators are also on the front lines litigating cases that will have an impact on a number of open issues around AI. They're defending 2 of the first AI class action cases brought against generative AI, in leading the defense of a copyright class action suit challenging the development and use of GitHub's generative AI coding tool, Copilot, as well as recruiting AI in defending a nationwide employment class action involving Workday's AI-empowered resume screening tool. Our corporate lawyers are also globally representing many high-profile AI companies and can call upon the resources of our wide range of practices to assist in providing cutting-edge advice to those companies. In my own practice as a technology M&A lawyer in Silicon Valley for the past 3 decades, I recently had the opportunity to represent 2 cutting-edge AI M&A transactions in Mosaic ML's $1.3 billion acquisition by Databricks, as well as in the legal tech space, the recent announcement of Thomson Reuters acquisition of our client CaseText and their AI legal tech platform, counseled. And so not only am I personally involved in terms of my M&A activity as the co-head of Orrick's global M&A and private equity practice, but I'm having opportunities to learn a lot about the broader artificial intelligence landscape and really being a spokesperson for that expertise in this presentation. As we think about AI and machine learning, we think about two major groups of participants: enterprises and their investors that are developing and deploying AI and machine learning based systems, and then the large number of enterprises that are licensing or acquiring and implementing AI tools for use. I don't need to tell this group, but generative AI is new in terms of its capability to generate text and images, video and audio that matches or nearly matches what humans can do. But we need to remember that it's not a true artificial intelligence. We can't trust the machines to be thinking behind the scenes. There's really no underlying logic, but rather guesses about what users want based on data that it is trained on. And so generative AI has all the same risk as humans generating content, but without the intent to guide the output. When we think about a framework for identifying AI risk, it's really a simple flow chart. On the one hand, you've got AI training inputs along with AI use inputs or prompts that are fed into an AI system or model with its algorithms and software code and its weighting to generate AI outputs. And when you think about that flow chart, companies start to ask questions about where was the data obtained? Is the use of that data in these platforms consistent with applicable licenses to the data? And what are the IP problems with using data, copyright problems, et cetera, not only in the prompts, but as well as in the outputs. Getting data to train these models has significant IP implications. Many are, as I mentioned, in the first swath of lawsuits were alleging copyright infringement from using data to train models. There's also implications of using the model outputs. Can you own the outputs? What happens if your employees start using these models, and are you at risk of losing ownership of your own IP? In thinking about some of those risks, you constantly need to ask yourself, how is the data being used? And as a general rule of thumb, anything likely to impact another company's business and anything published onto the public generates higher risk. As I mentioned, in terms of some of the risk on both inputs and outputs, copyright infringement is at the moment by far the #1 issue. And there's a legal question that is still to be resolved as to whether training a machine learning model on copyrighted material is a fair use, or if there is an intermediate use under the copyright law, where you're reverse engineering, so to speak, using the material not to reproduce the work as the ultimate end product, but rather to understand the underlying relationships of the data. Is that a different use that doesn't run into copyright liability? And it's important to remember that at this point in time, no court has yet held that training a machine learning model is a fair use of any type of copyrightable subject matter. So clients that we advise them that reproducing copyrightable subject matter to train a machine learning model is a risk that is still subject to ongoing litigation and the development of case law as well as regulation in this space. As I mentioned before, the regulators have heightened concern around privacy and rights of publicity. Due to the vast amounts of data that is processed by AI systems, companies have to be aware, as I mentioned, of understanding where the data comes from, whether it's able to legally use that data, and can sensitive personal information like health records, financial information be disclosed through the utilization of these AI models. As we know, AI systems can make decisions on personal information without consent, which is a core feature of privacy law. And it raises the question of the extent to which individuals are in control of their data and how it's used in an AI system. Another core feature of privacy law is data minimization. And that's totally contrary to AI, where large amounts of data are incorporated and necessary to train the models. Finally, transparency is another core principle of privacy laws and regulation. And understanding how decisions are made in relation to data becomes increasingly difficult as the AI systems become more and more complex. and it's hard to understand how the decisions are being made, and the lack of transparency makes it difficult to hold ownership of the systems accountable. Another issue in terms of the risk of AI systems is kind of a user's IP freedom to operate. Is the company going to get sued for infringement based on use of generative AI systems? And can you exclude others from use of the outputs, which is a hallmark of ownership? There's trade secret exposure in having certain clients' information exposed to others, either by employees of a company inadvertently using these generative AI tools and having under the terms and uses of those platforms, that information becoming owned by the platform and effectively losing the ownership, not to mention the confidentiality and or privileges associated with that information. There's also risks to data security that need to be considered. You know, where and how are you storing these the data that is being used to train these AI systems, and thinking about appropriate levels of security at each stage of the system. As I mentioned, competition, algorithmic pricing coordination, trading coordination on the securities exchange, other applications raise antitrust issues. There's also issues around securities regulation for public companies that now need to think about the disclosure of risk profiles in either their deployment of AI systems or their use of AI systems. We also have the issue of hallucinations, or the very confident and believable responses of output from the AI systems that aren't really justified by the training data or are false or nonsensical output. There's recent publicity around and lawsuits around inventions of a harassment scandal, for example, and naming a real person as the accused completely falsely. Defamation suits alleging that a chatbot invented false accusations about a whistleblower. A lawyer creating a legal brief and submitting it before a court with completely made up citations. And so there's risks around the output in creating false information. I mentioned bias and discrimination as another risk in tenant selection, in hiring, in lending practices, as well as other manipulative and dark patterns or other things that can make consumers more susceptible to phishing and other deceptive practices. So with all of these risks proliferating out there, there not being much regulation, what do we do in terms of trying to establish a framework for AI governance and risk management for our clients? The low-hanging fruit, we get questions from clients about, do we have to update our privacy policies if we're using AI systems? What are the vendor management questionnaires or frameworks that we should use when partnering with an AI system or service providers? There's also an acknowledgement in trying to establish governance that there can be a tension between compliance and the innovation amongst the technologists, the data scientists, the software developers within the company who want to have freedom to maximize the data that is utilized and maximize the potential for the systems that are being created. Among the strategies to minimize risk that we talk through with clients that are facing these types of concerns are the build or buy decision, attempts to filter the prompts and outputs, service models with licensed training data set and commercial service terms. So there's an evolution of different flavors of licenses and use models for many of these AI systems. Training employees to avoid prompt-based risk and how they should be utilizing and not utilizing in certain instances these platforms. Creating sensitivity within the organization to models trained in a fashion that creates enhanced risk, and robust clearance processes prior to commercialization of outputs. As one framework, as we think about preparing an organization in the absence of a mature regulatory framework, we hearken back to the NIST framework that they've used in other contexts, in the cybersecurity space, in the privacy space, as those areas and regulations have evolved. The National Institute of Standard and Technology under the Department of Commerce, which is a private industry that takes on, that collaborates with participants from private industry, academia, nonprofits, and trying to create a centralized framework for advising companies at this stage of the industry in how to develop governance frameworks. These frameworks have historically been a blueprint for federal regulation, and it establishes a baseline for a company's own internal management of risk. The reason that this is advisable, and some of the techniques and processes that we're advising clients on, is that they're often widely adopted and followed between contracting parties, even in advance of regulation. And they also have established a standard of care, at least a baseline for such standard, in lawsuits that may engage. And historically, in these other contexts of cybersecurity and privacy, if a company has not taken any action to have a framework for mitigating risk, it can be detrimental to them in some of those types of challenges. Essentially, the goal of the AI risk management framework is to offer a voluntary resource to organizations for designing, developing, deploying, or using AI systems to help manage the many risks of AI and promote trustworthy and responsible development and the use of AI systems. It's essentially a framework developing compliance systems in anticipation of legislation. And it really focuses on three general risk profiles: harm to people. That can be in the form of inaccurate information leading to bias, as I mentioned, bad decisions, for example, for making insurance decisions or loan eligibility decisions or hiring decisions. A second category is harm to organizations, where old or bad data could push organizations into harmful conduct and or move towards doing things with the outputs that could be competitively harmful. And then there's the third area of harm to the ecosystem, given the vast computational costs for developing AI systems, as well as the impact on the environment and the planet. As we think about core risk management activities, it's really in two separate interrelated steps: governance, kind of an overarching concept designed to be a cross-cutting function to inform all of the other functions. And the other AI risk management activities fall into mapping, measuring, and managing AI risks. It's a fairly simple concept and structure, but it's more about developing an internal process that in which the application can become very nuanced and difficult. But the overall objective of adopting some of these risk management structures within an organization is really about creating transparency and trustworthy systems that are accountable and transparent to the regulators' concerns, to the commercial concerns, to the concerns of consumers, and also making sure that these systems are valid and reliable in terms of being safe, secure and reliant, explainable and interpretable, privacy enhancing, and fair, with harmful biases managed as best as they can. So as I mentioned before, as a firm that, as one of our three pillars of strategy, is a technology firm that prides ourselves on innovation. As I mentioned, we have a cross-disciplinary team that has been thinking about these types of issues for a number of years in anticipation of this moment in the development of Silicon Valley and beyond, and this next wave of innovation, and how we can not eliminate the use of this, or as I jokingly alluded to, throw a wet blanket on the proceedings, but really foster the use cases and consumers' desire and companies' desire to really take advantage of the benefits of this new technology and what it will mean for all of us in the economy and in the society and in the future in the years ahead, in a way that mitigates the risk as opposed to eliminate the risks. So those are a few insights and perspectives, in large part compiled from our interdisciplinary team that has been on the front lines counseling clients on these very issues as things evolve. And we'd be thrilled to meet with general counsels and other risk management folks, as well as the technology teams, to help try to bridge the gap in information and communication between those players in any given company to the end of deploying this technology in as risk mitigated a manner as can be conceived, in anticipation of what is sure to come in the form of additional guidance from regulators in this new and exciting space.